Yep, you might. Oh, she's starting it up. Okay, never mind.
Sorry, what did you say, David? I missed that.
I'm sorry. She was starting up live the recording and that sort of thing, and you were headed on down the road.
Okay. Well, I don't think recording my remarks on video is necessarily something that has to happen. But anyway, Bill, let's keep going.
So I think we have now moved to the next question of, we've moved on to the next question of how long should there be a time specification for when the appellate court must rule on the motion? And do we want to build into that denial by operation of law if there's no affirmative action on the motion? The task force draft rule had set a 3-day time limit. And I think Chief Justice Christopher and some others had expressed concern that that was really too short of a time period for the Court of Appeals to give this the necessary attention. So I might solicit Chief Justice Christopher, Chief Justice Gray, or Justice Kelly, or others who might have thought about what a reasonable period of time for the Court of Appeals to act would be.
Yeah, great. And Pete Schenken darted his hand up there maybe before you started speaking and after I did. Pete, did you have something preliminarily to say? You got to go off mute if you're going to talk. Well, maybe that's an inadvertent hand. You never know. So Pete, we'll get back to you if we need to, or if you want to speak again. But members of the task force, Justice Christopher.
Well, given the way we've phrased the motion, I'm all right with 3 days, but I wouldn't have an automatic denial.
Why?
Why wouldn't I have an automatic denial? Because, 3 days is aspirational, right? I should get it done in 3 days, but if I get it in four or 5 days, then it's okay. But I think it's good to, give us that. Or what if I am reading the brief and realize, oh yeah, okay, I should have granted that motion. So I wouldn't put an automatic denial in there. I think that's a bad thing.
So you would also want to change the word must, right?
No. Must is still good. I mean, we want to have a deadline. We want to say, okay, I got to get it done in 3 days, but and we do. I mean, we're very fast on motions in parental termination cases. When people ask for extension of time, like in my court, we usually have 3 judges, but if this rule passes, I would go back to the option of just having 1 judge rule on the motion, which we're allowed to do under the appellate rules, just to keep things going. So I think the faster the better. So
if you leave must in there, even if you take out otherwise it will be denied by operation of law, don't you leave open the argument from somebody saying, well, they denied it because they had to act in 3 days and they didn't?
I don't think so. I don't think that's the way case law goes, but I could be corrected.
I would be hesitant to correct you on case law. Lisa.
Thank you, Chief Justice Christopher, that the 3 days didn't scare you. I was thinking that was way short. I do agree with you that unless it says denied by operation of law, that is such a unique thing in very unique places that we have it, that the failure to rule would not be a denial by operation of law in a case unless there's express language somewhere that it is. And then I guess I just would ask the same chiefs, if you deny these within 3 days, is there a perception from the terminated parent that maybe it wasn't given enough consideration? Like if you grant them and they get their hearing in the trial court, they're going to applaud you and say, good job, you did that quickly, I'm going to get my hearing. But I guess that short of time frame, I'm raising the issue as if perhaps there is a perception from the litigant, not from the lawyers, but from the actual party, that it wasn't maybe given its full consideration, particularly when it's denied. And that's just my only comment with that rule, with that time proposal.
Thank you. Justice Gray.
Well, it's interesting that you have 3 days here, and I could not quickly find the rule that doesn't count weekends if it's less than 5 days notice or something. So, you know, that might trigger a longer time, but basically I'd flip it and then say, unless it's granted in, or unless it's denied in 3 days, it's granted as a matter of law or deemed granted. Because with, you know, if Tracy can get these done in 3 days by one judge or 3 judges, my hat's off to her. But 3 days, as Lisa anticipated, that is a tough deadline to meet and make a meaningful decision. If you're going to glance at them and say, yeah, let's develop the record, then why not have a presumptive grant and let the trial court deal with it. The other more fundamental thing to me is with 3 days, a written motion, you're basically talking about ex parte. You've provided no opportunity for anyone else to file any response to this in the rule. And practically with a 3-day window, you've denied it procedurally. I mean, maybe you give them 3 days to file a response and 7 days to rule on the motion, but that 3 days to me is unreasonably short unless it is a presumed grant.
You know, we had that long discussion in the Supreme Court Advisory Committee about the fact that we have a 3-day notice for hearings, right? And people are like, well, that's ridiculous. Nobody can file a response. Nobody can, you know, we need to change it to 7. We need to change it to 10, and it never moved, right? It's 3 days notice for a hearing. I mean, do I want to impose 3 days on me? No. But do I think it's a good idea? Yes. I mean, we rule on emergency stay motions quickly. And to me, this would have to have the same urgency as an emergency stay. And so, and I also think I could look at the motion, and if they have an affidavit of 2 witnesses that said, I would have said these things, I'm going to send it back. So if they just say my lawyer didn't call any witnesses, I would say, no, you know, you're not particular enough here. Or, you know, they didn't file a motion for continuance and I needed one. You know, I mean, I just, and Tom's right that it will be a, you know, it'll be a quick look through on a 3-day notice. But I just think, again, like Bill said, you got to balance the time limits here.
Yep. All righty. I thought you were going to point out that as chief, you have control of your court, but you didn't make that argument. So
I'll have no comment on that.
all right, Roger.
Following up the query about what do the rules provide about time, Trap Rule 4.1 says that in the if the day of the act, event, or default after which the period begins to run is not included, et cetera, et cetera. So we have a situation here where we do have a rule that tells us a little bit, but it's not, and says if the last day falls on a weekend or a legal holiday, it doesn't count. And in other words, what I'm concerned about here is that even under this rule, if the motion gets filed at 5:30 or 6 on Friday night, we have a situation where maybe it's not even going to be seen by staff and considered till Monday morning. And that gives the court maybe only one day to evaluate and respond. Whereas if it was filed on a Monday, there might be a few more days involved. I don't know whether that is enough to say increase it from like 3 to 5 or not, but I think it might be a concern that might merit some discussion. That's it. Thank you.
Great, thanks. Justice Gray, did you re-raise your hand or is that from the last time? Must have been from the last time. Okay,
It was
Go
a
ahead,
leftover. It was a leftover hand raise. Sorry about that.
no, that's all right. That's okay. Anybody else want to talk about 3 days versus a different period of time? And then also whether denial by operation of law. Any other comments about that? All right, well, let's have,
Can I say,
yes,
if we leave out denial by operation of law, would that permit the Court of Appeals, even as late as reading the appellate brief to make a decision to remand for a fact finding? And would that be a good thing?
I took Justice Christopher's comments to suggest that the court would have that ability if you took out the denied by operation of law language. She can speak for herself, but that's what I took her to say.
I think that would be very beneficial because the initial review on a quick timetable of 3 days, maybe after more sober consideration of the record and the issues raised in the appeal, that the panel might decide that they want to give the appellant an opportunity to develop the facts. And so while even if it's overruled by operation of law, maybe they still have that power, that would make me inclined to not overrule by operation of law.
Okay, Justice Gray, is your hand meant to be
Yes.
back up again? Okay.
Yes, it is. I would change the word must to should and not have the denied by operation of law to preserve our ability to carry the motion until we see the briefs and the full record. And I realize that at that point, the issue needed to be briefed and maybe it has been, but I would want to make it a nudge towards carrying a motion with the appeal for a little bit longer. In deference to what Bill's talking about, we are balancing the constitutional rights against rules and statutes and a deadline that is imposed by the Supreme Court. We are not balancing between two constitutional provisions, and this is going to be hard enough to administer and decide and process as it is. And with 3 days, I would put should rule on it in 3 days and not have a default provision for denial. Thank you.
Got it. Roger.
Well, perhaps a compromise could be that instead of saying it's overruled by operation of law, is to say that it is deemed overruled pending further consideration by the court. First, you get the effect of a ruling so that the party will know okay, it's effectively resolved, but the court may reconsider later. Kind of like the court's plenary power after a motion for new trial is denied. Second, you would at least have a ruling. So if you have a, shall we say, an adventurous counsel, he could file a mandamus, at least file a mandamus to the Supreme Court saying, I've got an effective ruling. It should have been granted in a heartbeat. So perhaps that compromise language that it's deemed pending further action by further consideration by the court would allow you the effect of having a ruling, but then give the court latitude that if they think about it some more and later on, they could say, well, we're going to exercise our power now and grant it. That's my thought.
Okay, Bill, what's your reaction to that?
I'm getting a little concerned about making this complicated rule more complicated. I think I'm hearing consensus building around 3 days with room for discussion about should versus must and denied by operation of law. I guess my thought would be the Court of Appeals, let me say it this way, taking out a reference to pending reconsideration wouldn't change anything because the Court of Appeals would already have that authority. It could deny it initially, get the briefs, get the record, look at it and say, we denied it before on a, without a record in front of us, but now that we see it, we think there's potentially something here, so we want to send it back. So I think what I'm suggesting is 3 days should rule on, leave it at that.
Okay. I'm going to hold that in the form of a motion, but Professor Hoffman had a comment.
I did. Thanks, Chip. Speaking of a complicated rule, and I don't know the rules well enough, so maybe somebody else could jump in and tell me if I'm wrong about this, but isn't it all these references to what the trial court must do, which essentially is like the second half or more of this entire proposed rule? But is that common to include directives to the trial court in the Texas rules of appellate procedure? I would think it is not, but again, I don't know.
I think Pam has a comment.
Pam.
Yeah, there are directives to the trial court in a number of rules, including ones about supersedious, ones about orders during an interlocutory appeal on temporary orders. So no, I don't think it's that crazy.
Okay. What Bill? Let me see if I can formulate something to vote on. What if we ask people to express their views on whether the appellate court should rule on the motion within 3 days and strike, otherwise it will be denied by operation of law? That's what I heard you kind of say a second ago?
Yes, that's what I intended to say.
All right, so let's vote on that. Everybody in favor of the rule saying the appellate court should rule on the motion within 3 days, period, striking the language, otherwise it will be denied by operation of law. Everybody in favor of that, raise your hand. All right, everybody, drop those hands now, please. And everybody opposed, raise your hand, please. Everybody finished voting? All right, that passes by the vote of 29-2, the chair not voting. And so we will move on within this rule. Bill, and where do we go next?
Hey, Chip, my vote was with the first one. I just didn't lower my hand fast enough.
All right,
it was
so-
one.
Mine too. I think if I was the second vote, I noticed it was still up.
Yeah, it was the second vote. So it's unanimous.
Thank you.
31-0. Thank you. Glad that
So-
nobody's hacked into our voting machines on this. All right, so go ahead, Bill.
So I think the next couple of deadlines really go to the trial court proceedings. And so I would solicit the trial judge's views about what is an appropriate amount of time for within which to require a trial court to hold an evidentiary hearing on the referral and sign an order.
Okay. And Richard Orsinger, who is, to my recollection, not a trial judge, but thinks he is. So go for
No,
it.
I just wanted to say this. I can wait until later, but I think that we need to have a consistent measure of the passage of time and events. And it starts out by saying the trial court must begin the evidentiary hearing, but then findings of fact and conclusions of law are due so many days after the hearing is concluded. And remember that one of the considerations we had was that sometimes courts will start a hearing in an artificial way by swearing in one of the parties as the first witness and then recessing and then not meeting any kind of deadline to conclude the hearing because they started the hearing. So I think we have to be alert to the fact that some trial courts may begin the hearing in a perfunctory way and then recess it for a period of time. The trial court's obligation in the next sentence is to make findings of fact and conclusions of law. But in the following sentence, you have a blank number of days from the date of the trial court's order. So I'm not clear on whether the trial court on referral is merely making findings of fact and conclusions of law to forward to the Court of Appeals to make an order, or whether the trial court is making an order like the granting of a new trial. So I think we need to calibrate or coordinate findings of fact and the concept of an order. And then at the end of this, we have an extension of the 6-month timetable is capped at no more than 20 days. And so that's a hard cap, even though the deadline may not be a hard deadline, that's a hard cap. But because the trial court can begin the evidentiary hearing without a deadline on when it's concluded, that could easily be more than 20 days. The trial judge could stretch it out, and all of a sudden now the Court of Appeals is still stuck with the 20-day deadline, even if it took the judge 30 or 45 days to do it. So I feel like we need to coordinate the deadlines with the beginning and ending. We need to resolve whether the trial court is doing findings and conclusions or rendering an order. And we need to be sure that the internal deadlines or date periods all add up and match the tolling period for the Court of Appeals. Thanks.
Judge Miskell.
I'm going to put something in the chat, which is a link to Texas Family Code 109-001B2. And that is the provision that allows the trial court to grant temporary orders pending appeal. And the way that they have phrased the court's authority and time limit to do those temporary orders pending appeal is the Family Code says the trial court has jurisdiction to conduct a hearing and sign an order until the 60th day after the notice of appeal has been filed. So that is a complete cap on you can have the hearing on the 60th day, but you also have to sign an order the same day. And there's no extending past the 60th day. So however many days and whatever date you measure it from, you could copy this approach and say, the trial court has jurisdiction to conduct the hearing and sign findings of fact and conclusions of law until X date after Y, whatever.
Great, thank you. Lisa, I think you're next, and then Munzinger.
I just want to reiterate Richard's concern about how trial judges across the state of Texas are actually starting hearings in some fake way, I'm going to say it, that gives them, like, alleviates some pressure on them for statutory timelines. It is happening more and more frequently in the cases that I'm seeing on our CPS docket. And it's frustrating and very problematic. So I just don't want that comment to get lost of just one practitioner's experience. I also am seeing that across the state. And Judge Miskell's thoughts about the way that the family code provision that she cited in the comments addresses that might solve that problem. I'd have to think about it a little bit more.
Richard Munzinger.
Both parties to the case have interests in the final judgment and in the final resolution of the issue. And I think it would be a mistake to not have some kind of hard cutoff date requiring a trial court to hold a hearing, enter its order and findings of fact and conclusions of law within a particular time. And the 60 days that she just suggested, and to follow that rule seems to me to be a good one. You can't just let this thing pend, and trial judges are not all that anxious to get into these things. There needs to be a time limit. Thank you.
You betcha. Judge Mendoza.
So I have to preface this by saying that I don't do any family law. I just handle criminal. So my experience is based on how these things happen with me. And I frequently, well, not frequently, I should say, every once in a while, have orders from the Court of Appeals that I must do something by a certain date. And it's tough. It's tough, I will say that. So I think that in these cases where you have to have an evidentiary hearing, even if you had a really on the ball trial judge and they scheduled a hearing, let's say within 10 days, I think that's tough for the parties in these types of cases to line up witnesses or whatever they need to present to develop their IAC claim. So that's more of a concern for me, that it'd be sufficient time for the parties to get their ducks in a row for a hearing. But I like Judge Miskell's suggestion. And again, I don't practice in this area, but I know we're working on some really tight deadlines. I would suggest we do something like the rule that Judge Miskell is referencing, but I would cut it off at 30 days because I do think while it's tough, everyone else is working on real tight timetables, 10 days, 3 days. I think it'd be a good thing to push the trial court at about 30 days. You want to wait till the 30th day, that's on you. You're going to have to do everything on that day. And by the way, when the Court of Appeals tells me to do something, I'm usually going up until that last day, having the hearing, doing the findings, all on that last day. So, but I think 30 days is reasonable in this area.
Thank you, Judge. Judge Schaefer.
I think the idea of having a time frame during which the whole thing needs to be completed and then letting the court do the individual items that are contained within this rule within that time frame is a much better idea, because we all have to keep in mind this isn't the only thing these courts are doing when these hearings are going on, especially in the family court arena. Judge Miskell and others can talk about that more than I can because I do none of it, but I hear from my colleagues, and it's an everyday process on the bench. And if you throw this into the process and force them to all of a sudden have to just stop everything else, that's going to create other problems for these courts. So I say make a deadline for which everything has to be completed and then leave it up to the trial court to schedule it.
Thank you, Judge. Pam.
Well, I was going to say something similar, which is just to peg both the hearing date and the findings and conclusions date to the referral order so that they refer back to one certain date. And I think the idea may be of saying the trial court will hold a hearing and issue its findings no later than X days after the referral date would give the trial court that flexibility. I think it has to be a shorter time frame than we've been talking about. And in terms of the family law code provision, I'm not sure that would apply to this because here we're not asking the trial court to make an order. We're asking the trial court as an adjunct of the Court of Appeals to hold a factual hearing to assist the trial court in deciding a motion. So it's a little bit different. It's a little bit like abate and remand for making findings of fact and conclusions of law. You don't look at whether or not that's within the particular jurisdiction or time period in which the trial court can act because it's doing something basically as a referral from the Court of Appeals. Court of Appeals can do that too if there are fact issues on whether the Court of Appeals has jurisdiction. So there again, the trial court's acting as an adjunct to the Court of Appeals and not making its own order. So I think that's sort of questionable, but I would say 20 days from the date of the referral, the trial court has to have had its hearing and made its findings. We really got to keep this train on the track and we can't slow the Court of Appeals down too long. We want to make sure that everybody gets their constitutional rights protected, but we've got to do it very quickly because of the interests at stake.
Thank you. Judge Stryker.
I would echo everything that Judge Barron just said. I think I do mostly family law, and I would say that if I can't get a hearing scheduled in 2 weeks and then give me another week to do the findings of fact and conclusions of law, then my train has gone off the track. So I think we can do it. And I think there needs to be a sense of urgency. So I would agree with, I was going to suggest 21 days.
All right. So you and Pam are within a day of each other. Great. Bill.
So I was going to say that it sounds like consensus is building around setting the outside deadline as opposed to the beginning deadline. And I think Richard's and Lisa's points go to that. 20 or 21 days and changing order to findings and conclusions so that there's consistency throughout. I think I'm hearing consensus on those points.
Not so soon. Judge Miskell wants to weigh in.
I was just going to say that in courts that hear CPS cases, we're very used to having evidentiary hearings on short deadlines because every CPS removal case begins with, we have to have an evidentiary hearing within 14 days of when we sign the removal. So if your docket has CPS cases, you're doing evidentiary hearings within 14 days of the time a case pops up. So if it's the 20 or 21 day deadline that everyone's talking about, I think CPS courts are used to having to do things that rushed.
Great. Bill, was that your hand up from previous comments, or you want to say something again?
That was me failing to lower my hand.
Lower your hand. Orsinger, same thing with you?
No, I have a comment to add,
Okay.
which is that, yes, I agree with what Bill just said, that we're not expecting to have an order from the trial court. I think we're expecting to have findings and conclusions and let the Court of Appeals do the order. Is that agreed, Bill?
Yes, that's what I'm understanding, and that's consistent with us getting away from the trial court making recommendations. The trial, what I understand us to be talking about here is the trial court is going to say, make findings, yes or no on ineffective assistance, yes or no, on prejudice.
Okay, so there's another internal deadline here, which is the court reporter's deadline. And I want to make a suggestion about that, but I also want to say, rather than having the deadline that the trial court must make findings, which doesn't get those findings to the Court of Appeals. So does the clerk have to forward them? Does someone have to request them? Can one of the lawyers file them? I would suggest that the deadline not be to make the findings and conclusions, but to file the findings and conclusions with the Court of Appeals. And that eliminates a few days delay if the trial judge has to be responsible for getting them filed. With regard to the court reporter's record, this court reporter's record is based on when the trial court issues its order. The trial court's going to issue findings and conclusions now, but the hearing may have been concluded 10 days before the findings are ready. And it seems to me like the court reporter's deadline to file the court reporter's record should be when the hearing concludes and not when the trial court issues its findings and conclusions. There's no reason to have the the court reporter wasting time not preparing a record when the evidence is closed.
Justice Gray.
To follow up on Richard's point, my concern here is the requirement that we have written findings and conclusions. I would much rather give the trial court the flexibility to dictate those on the record and not require a separate document that has to be filed with the clerk and then forwarded to us in a supplemental record. And so I would like to see the rule have that flexibility to expressly make the findings on the record. And on this point, I'll close. I have a gnat on another point, but I'll get back to that when appropriate.
Well, I think nobody else's hands up, so why don't you do your gnat now? Is that different from a nit, by the way?
I don't know what a nit is. I know what a gnat is. So
okay.
The proposal says after the referral order is signed. I don't know exactly if that contemplates a per curiam order, which is normally the way these would be done. They would not be physically signed. And so I would just change that phrase to after the date of the referral order period.
Great, thank you. Any other comments? Bill, do we have anything to vote on? We sort of have a bunch of different thoughts here, but if you think there's something to vote on, do it.
Yeah, let me see if I can articulate this. So let's see. I just saw a helpful email that may already have crystallized this. So let me look at that real quick. Courtesy of Rich Phillips. The trial court shall hold a hearing and file its findings of fact and conclusions of law no later than 21 days after the date of the referral order. I think that captures everything we've talked about, except for Chief Justice Gray's comment about whether we're going to insist on an actual document with findings and conclusions. But if we could put that aside for a moment. So I guess I'm making a motion for the committee as a whole to vote on a revision to the proposed rule that would say the trial court shall hold a hearing and file its findings of fact and conclusions of law no later than 21 days after the date of the referral order.
Okay. Richard Orsinger?
Yes, so we would amend that, I think, to say shall make their findings of fact and conclusions of law rather than file them so that they can be done in the reporter's record. But I think we're micromanaging here at the end where we require the court reporter, which by the way, as I said, the deadline should run from the end of the hearing, not from when the findings are filed. But anyway, the court reporter must file a supplemental court reporter's record and the clerk must file a supplemental clerk's record. Do we really want all that? Or do we just want the court's clerk to email the findings to the Court of Appeals?
So can I carve that out for a subsequent consideration? Because I think we're dangerously close to having a short statement on what the trial court has to do. And I wanted to see if we could have the vote on that. So with Richard's amendment, the motion would be to revise the proposed rule to say the trial court shall hold a hearing and shall make findings of fact and conclusions of law no later than 21 days after the date of the referral order.
Okay, everybody got that? Everybody in favor of that, raise your hand.
Not to be difficult, but can you read that again?
Potentially. The trial court shall hold a hearing and make its findings of fact and conclusions of law no later than 21 days after the date of the referral order.
Okay, everybody voted in favor of that wants to vote in favor of it. So lower your hands now, please. And anybody who is against that, after all hands are lowered. Okay, I have 2 people voting against it. Judge Wallace and Tom Riney. Is that accurate? You guys want to vote against that?
No, I just forgot to lower my hand.
All right, that's what I thought.
And I was too
Tom?
low, lowering mine.
All right, the vote is unanimous, 32-0. And so, Bill, let's keep rolling here. We're on a roll.
So then could we take up the question of what specific deadlines, if any, do we want to impose on the court reporter after the trial court takes this required action within 21 days?
Let's take that up right now. Tom, do you want to say something, or are you still voting? No, doesn't know how to take his hand down. He's one of those gunners, Justice Christopher, that was always in the front row in law school, right? Had their hand up the whole time. Justice Christopher.
Well, I like Richard's idea of, why do we have to go through this whole process of, the district clerk's office and, everything like that. It's how we do everything at the appellate court. And every time we refer a matter down to the trial court, we include this kind of language in our orders. Because if somebody just files a record with our court, we don't consider it the record until it's, gone through the appropriate processes of, coming from the court reporter, coming from the district clerk. So I would hate to change that procedure. I don't really have a good feel on how many days, but that's why we have it that way, because the official record comes from the district clerk and the official record comes straight from the court reporter getting filed at the, the court reporter's portal, as opposed to somebody else doing it.
Thank you, Judge. Bill, what do you think? How many days?
I'll go with my standby, 7 to 10 days. And
Right, pick one.
I'll say 7 days.
7 days. David Jackson, what do you think about 7 days?
Well, when we originally started talking about these cases, gosh, years ago, parental termination rights, it was basically a drop everything and get these cases taken care of. And I certainly understand that. You're talking about the rights of a parent. With us, it depends on how long this hearing is for the effective assistance of counsel. If it's like 50 pages, we can do it in a day. If it's 300 pages, I mean, it's all based on volume and just how long and complicated these hearings are. So if the judge is willing to work, together with the court reporter to help them get these records out, it would help a lot to get that time limit lowered as low as we can get it. But it's going to require the judge and the court reporter to work together. The judge can't set a 4-week trial the day after.
Yeah. But in a vacuum here, 7 days is okay with you, David?
I think so.
Okay, great. Judge Stryker.
Are we saying 7 days from the conclusion of the hearing? Or 7 days from the court's conclusions or findings of fact and conclusions of law? I just wanted to clarify.
I think it's conclusion of the hearing.
That would make sense. Because that'll give them more time. The reality is the hearing's going to end and the judge is going to take a couple of days to do findings of fact and conclusions of law. So if it's after the hearing, that would give them probably a couple more days on top of the 7. If you do it the other way,
If you do it the other way. So the way this is drafted, it's 7 days from the date of the trial court's order. So that's not from the date of the hearing. So you think that's preferable, right, Judge?
Well, I think if we're going to do a short amount of time, the clock should start ticking after the hearing. Excuse me, if we're going to give a longer amount of time. If we're going to give a short time, then they can buy a couple of days by it being after the order's filed.
Yeah. Okay. Got it. All right. Other comments about that? Anybody opposed to 7 days with the language we have here? Okay, so I think we've got
Richard. Chip, I've lost the thread a little bit because there had been some discussion about having the 7 days tied to the date of an order, contemplating a signed order. I think Chief Justice Gray had raised the possibility of the findings just being dictated. We've gone with language shall make findings and conclusions of law. So I think we probably want to tie it to the conclusion of the hearing to avoid confusion. And then whatever number of days is reasonable from that is the number of days we should have.
So you want the days not from the trial court's order, but from the conclusion of the hearing? Is that what you're saying?
Yes, I think that will be less confusing.
Okay.
Or more certain.
Judge Stryker, is that okay with you? She says yes. Pam's got her hand up.
Yeah, I agree with that. I think it has to be tied to the hearing, 7 days. If David says it's good, is good. And the trial court is not making an order. So if we're going with that language, we would need to change it.
Right. Richard.
If the judge decides to file written findings and conclusions, that would be filed with the clerk of the court. So it seems to me that the duty on the court reporter should reference the closing of the hearing, but the duty of the clerk should be to forward the findings and conclusions immediately to the appellate court. There's no reason that the clerk has to wait 3 days or 7 days to forward written findings.
Yeah, that makes sense. Justice Gray.
There may be no written findings, or the more problematic for the proposal is that there are written findings and they're not filed until 4 days after the conclusion of the hearing, in which case the court reporter suddenly has, 3 days. Well, yeah, the clerk suddenly has no days to do, to forward the findings. So the problem is if they do written findings after the date of the hearing concludes, you're losing days in there that the parties responsible for filing an amended record, or a supplemental record with the Court of Appeals, they don't have any control of how long it takes the court to get those findings prepared and filed if they do written findings.
Right. David Jackson.
Are we presupposing that all of these hearings on ineffective assistance of counsel will be transcribed? I mean, a lot of times hearings aren't transcribed. So are we just taking it upon ourselves to start working on these the minute the case is over as a court reporter?
I think the answer is yes.
Okay. But
to make
clear.
the record capable of being reviewed.
Great.
Yeah. Okay. Any other comments? Okay.
So
Bill, go ahead.
So I'm trying to sync up the language with respect to what the court reporter can do. I think we're approaching consensus on 7 days from the conclusion of the hearing, but I'm trying to sync that up also with Chief Justice Gray's comment about district clerk filing a supplemental clerk's record containing written findings of fact and conclusions of law if they get separately made.
Well, isn't that the answer to it, Bill, if they get separately made?
That's where you could use the universal catchphrase, if any, period.
Well, I think what you should say, if not made on the record at the hearing.
Yeah.
So that people will understand what we're talking about here.
Yeah. Judge Stryker.
So if they're made on the record during the hearing, that means the court reporter has to prepare the transcript? Or else, how is everybody going to have this ruling to start all these timelines if the court reporter doesn't prepare the transcript for another 7 days? I feel like they should be in writing by the judge so that the times are specific and everybody knows that they're made. That's just me. I just feel like it could lead to confusion if there's any delay with that record.
Okay. Bill, any thoughts about the judge's comments?
I guess a way to address that is to require separate written findings and conclusions, which I think is within the ambit of what a rule could require. I guess I'm soliciting thoughts from the trial judges and the appellate judges in the Zoom room about how onerous that is, that being requiring written findings and not just allowing them to be recited on the record at a hearing.
Justice Gray.
Chip, I don't see anything that is pegged to a deadline once we get those findings in a supplemental record, whether it's a clerk's record or the reporter's record. Once we get those findings, then we can reinstate the appeal and go forward. The trial court's done their job. The reporter has done their job. If there are written findings, then we know that that's going to come in a supplemental clerk's record. And so we've got what we need at that point, and the rule doesn't have any further deadline then. So I'll be candid. I'm confused by where Judge Stryker thinks that would be a problem. So if Judge Stryker could help me out, I would appreciate it.
So I'm just trying to figure out if you make those on the record, which is going to be the very last, 20 lines or whatever it is. And then the court reporter files it when they're going to file it. Nobody's going to know that ruling unless you happen to be at the hearing, right? Until the court reporter's record is filed. And previously we were talking about putting the court reporter's record after the findings. So I guess we're adding another, they're going to have to transcribe the whole thing and file it before anybody's going to know the ruling. And I guess we'll require the attorneys to order the record.
No,
Right
I think the rule contemplates, as Bill said a while ago, the record will be prepared and filed. Nobody's got to ask for it. It's going to come to us. It's going to be to us under the rule within 7 days, unless the reporter asks for an extension. And everybody's going to, like you said, everybody that's at the hearing is going to know what the ruling is if they're made on the record. If they're not made on the record, then we know that the judge is going to have to file written findings. And I do have to agree with Richard on his comment about if we get written findings filed with the clerk seldom takes 7 days. Maybe we need to leave that as 7 days, but the clerk seldom takes 7 days to file a supplemental record after one of these hearings. But we're not going to move forward until we either get the findings from the clerk or the full record from the reporter, which under either scenario is going to be 7 days after the conclusion of the hearing if it's in the reporter's record, or 7 days after the trial judge makes the findings and conclusions if they're in writing. So.
Yeah, I understand your point. I get it.
Judge Esteves.
Well, I'm just speaking because Justice Boyce wanted some input from some of the trial judges. So I'm going to give you the overall. I get a lot of requests for findings of fact and conclusions of law, more from the Court of Criminal Appeals, some from the Court of Appeals when they remand for my criminal part of my docket. So I don't have a lot of experience in other areas, but I will say that 90% of the time, everyone's at the hearing. I make some of the findings on the record that are important, so that way the attorneys know what they're drafting in the next hour. So, I mean, practically what happens is when we have this hearing, the attorneys are going to turn around and put those findings of fact and conclusions of law in writing, and then send it to everyone. Someone will request maybe an additional one or two, and then I'll just be signing it. So it's not a burden necessarily on the court. The hardest part is just getting the hearing. We usually make our decision then at that time, most of the time. And I would guess that if it's the same trial judge that already heard that underlying case, then there isn't anything that they don't have to read any type of transcription from the court reporter, because they were there and they ruled on everything, and they can have an idea of whether or not he was ineffective. They probably believe they were ineffective anyway, and they're relieved that someone's doing this if that's how they feel, or they know what happened and why, because they had some additional hearings outside the presence of the jury or whatever they did to know why they weren't doing certain things or why things were excluded. So I would practically say that it is probably not, and I will say that probably 10% of the time I have had to draft my own findings of fact of conclusions of law, but those are, they're a lot shorter than some of the ones that the parties are going to want to put in. The parties are going to want to put in every single fact, and they're going to want a record before. So it has to be from the date of the hearing, because they're going to be asking for an expedited hearing so they can draft those findings of fact and conclusions of law, because they want a very specific record and they want to be able to do that. And so you need the 7 days. As far as the filing goes, I mean, I think my deadline when I have to make conclusions of law and findings of fact, I have to file it that day. I mean, that's the whole point. I mean, when we tell someone, hey, you have a deadline, it doesn't mean that they got to finish it at home. they were supposed to send it to me. So the filing and the making is the same deadline. It means the same thing to us. It doesn't matter if we made it, if we didn't, if I signed the order and I didn't send it to the Court of Appeal, or at least the clerk's office, and the clerk's office feels the same way. They have an order that says they have to immediately send it. Now, I don't know, because I'm not in a huge jurisdiction, but in the smaller jurisdictions, that clerk's going to do it that day. I mean, unless I did it at 6 p.m. that night, they'll do it in the morning, but we don't have a 3 or 4 day delay to the Court of Appeals. So that's practically not really an issue, but I'll let the clerks talk to that in those bigger jurisdictions. It's not an issue here. You know, everybody has their own clerk. We file something, it says this goes to the Court of Appeals, they'll do it immediately. So that's the trial, that's from one trial court judge's opinion. So practically 7 days isn't going to be enough for a long hearing for a court reporter. So the reality is there's going to probably be a request for an extension. That's just the reality.
Well, Judge Miskell, what's your thoughts?
I don't have any issue with a requirement that the findings of fact and conclusions of law have to be in writing and not made on the record. That's how we do it in civil cases. So I don't think that's going to be a problem. I think it's probably more confusing for everyone to try to orally make them on the record. But anyway, just my 2 cents. I did have a question. In counties that use like a centralized docket, like Travis County and I think Bear County, would these ineffective assistance of counsel hearings go back to the same judge that heard the trial, or would it just be assigned randomly?
I think in Bear, it would go back to the same judge.
Would that be just under local policy, like y'all would just probably do it that way, or is it there's something that automatically that makes it happen that way?
Well, I think it would be kind of, not exactly, but akin to a motion to reconsideration, which never goes to a different judge under local rules, has to go to the same judge. And to me, that's kind of what this is. I mean, it's reevaluating something that you've already heard. And so I think it would automatically go back to the same judge in Bear County.
As a Travis County practitioner, that would likely be what happened too, but it's more a matter of local protocol. There's nothing in the rules, the local rules, that would require that to happen, as I understand the rules in different contexts about when cases come back.
Thank you, Harvey.
I originally was thinking that I liked the idea of the oral ruling flexibility for the judge who's busy. But the more I've thought about it, I'm at least concerned about that because I think there could be some confusion. Let's just say the judge at the end of the hearing says, well, I don't think there was ineffective assistance of counsel. Well, did the judge just make the findings of fact and conclusions of law? Does that start the dates? You'd have a debate about that maybe. So it seems like to me it might be cleaner to require the written ruling, which is not that difficult usually. And I also think it'd be better for the Court of Appeals. They can find it readily. They can refer to it easily. So I think that I'm kind of in favor of the written findings.
Okay, Pam.
Well, I was also going to say that I think they should be in writing. And if they're not, then we get into an issue that we could bust our 21-day requirement. If the hearing is held on the 21st day, the judge makes findings from the bench, and then the court reporter has a week to get that up to the court. We're at 28 days and we're slowing everything down. So written is more definitive. We understand how it works. The court could get the findings and conclusions first, record to follow. That'd be fine.
Judge Evans.
I'm trying to think of what would be different about what I might say about the written findings, but I'm very much encourage you only to go with written findings. I know of no other situation where a trial judge makes oral findings on a record. Given the nature of advocacy, an oral finding invariably leads you to believe as a trial judge that you don't know how to speak clearly because they ask you to clarify. And did you mean? And that's not a good process. And it's more reflective. This is a serious issue when you're going to make this finding of an effective counsel. And I think it ought to be it could either be incorporated in the order. I would assume, since it just comes from the Court of Appeals, and as Justice Christopher just noted, you just make the findings and you just put that in writing, and in the chat portion I was reading from her. So I encourage you only to go with written findings.
Great.
So
Thanks,
yeah,
Judge.
I put some language in the chat, which actually combines the time to hold the hearing and the time to get the record up into one order. This comes from our orders. Okay, first you say you gotta hold the hearing, right? And then I'll read it out for the record. The court is directed to reduce its findings to writing and to have a supplemental clerk's record containing those findings filed with the clerk of this court, together with a reporter's record from the hearing within 30 days of the date of this order. So we have combined everything. We don't say 21 days to get your hearings and your findings done. We say 30 days, get your hearings, get your record, get your findings done. So that's one way to do it.
Okay, John Warren.
Thank you. I see I'm joined by, in agreement by Sharina Gilliland, the district clerk from Parker County. We both agree that, I'll just speak from urban county's perspective. We have dedicated staff that handles appeals in my office, as well as Ms. Felicia Petrie, the district clerk. But also the Court of Appeals and the Fifth Court of Appeals uses a system called TAMES that allows the Court of Appeals to upload the clerk's record automatically. But if there's a supplement, we just like Sharina says, we'll get it there timely. I'm not quite sure that's an issue. I think from a clerk's perspective, we just need to know the date that the deadline for when that record needs to be in the Court of Appeals.
Thank you, John. Bill Boyce.
So I think the path forward may be to revisit our prior vote, as much as I hate to say that. If we go with Chief Justice Christopher's proposal, then what we're saying is that the trial court must hold a hearing and make its findings of fact and conclusions of law in writing no later than 30 days after the date of the referral order. And then we would have a date for filing a court reporter's record and a supplemental clerk's record X number of days after that 30 days. I think that's the logic of it, isn't it? We require the findings to be in writing, so we're not going to get a disconnect between potentially how they get made.
Right.
I think that's where we are.
I think so.
Well, maybe I'm misunderstanding, but I thought Chief Justice Christopher's language that she read us set an outside limit for everything to have happened. So you would have to have the clerk's record, the reporter's record, everything there within 30 days. You're saying that you want to break that into two pieces.
Well, let me look at.
And anytime we do this, we're moving beyond that 21 days that we had talked about.
So my draft that I sent everybody in the chat that I've emailed Bill is everything all at once.
Okay.
Right?
Okay. All right.
So it's not 21 days plus other days. It's 30 days total. And I did see Judge Stryker was a little worried about the court reporter having time to get it done. And I see David nodding on that. Also, if the judge waited until the 30th day to get it done. But I think that's the kind of thing where the judge and the court reporter have to work together. I mean, we really, this is our standard language that we use in all of our remands for like a missing record or a withdrawal of child counsel, etc. And we really haven't had problems with it in terms of, getting it. And like I said, if the court reporter's record comes up a couple of days later, we take it. So, but I think it's kind of a neat way to make just one package. Everything has to be done by this time period.
Judge Mendoza.
So I just wanted to say that that's where I started, right? Having said that this is not an area that I practice, I started with the idea that I thought Judge Miskell's suggestion was good, not because I was arguing jurisdiction in the trial court or whatever. I just said a drop dead deadline, and Justice Christopher's right. If I'm not a nice judge, I'm waiting till that 30th day, and then my court reporter is stuck because she's got to file it that day. But a good judge is going to take into account it's 30 days period. So have your hearing, make sure you give enough time for your court reporter to do what they need to do. But that was sort of where I started, and I deferred to those judges that do handle these cases that were looking at 2021 days. But I think this is a way to go, just a drop dead. And I had said 32, not 32, but 30 also. And then I was just going to say, and I know that this is not the best practice, not something I do, but we do have findings and conclusions on the record sometimes, and it's motions to suppress. It's a short hearing. It's really quick, and you can make your findings and conclusions that day right on the record. Anything complicated, obviously the best practice is to make the written findings. I'm not arguing that we change that. But there are hearings where trial judges make findings and conclusions at the time of the hearing on the record. And it's nice for judges that are busy and can make a decision on the spot and then move on.
Great. Thank you, Judge David.
Well, the 21 days would be very helpful, especially if it's clear that these are going to be transcribed, because that becomes the issue. Right after these hearings are over, are we going to have to make a record? Who's going to pay for it? How are we, where do they want it sent? But if it's clear that we're going to start transcribing these as soon as they're over, then the 21 days is very helpful. And, we can just take off from there and get it done.
So, Chip, can I call for a vote on one thing to kind of move this along? How about a vote on whether the findings and conclusions need to be contained in a separate document as a threshold matter, and then that will drive the next vote.
Okay, let's do it. So frame the vote. The first vote we're going to take is
the motion would be that the rule requires findings of fact and conclusions of law upon referral, that the trial court make those in writing as a separate document.
okay. Everybody in favor of that?
And let me just, can I give an anecdotal? It's pretty funny. So a judge did all of their findings on the record, and they just got the court reporter to type it up and signed it. And so it was the court reporter's transcript with the judge's signature on it.
All right, everybody put their hands down. Anybody opposed to this? Professor Hoffman, Judge Stryker, are you opposed? Judge Mendoza, you opposed? Yeah, okay. Justice Gray, you opposed? Okay, Roger, opposed? Richard opposed? Okay, so the vote is 30-4 in favor. Chair not voting. Okay, Bill, what next do you want to vote on, if anything?
So I think the next vote would be a motion based on Chief Justice Christopher's proposal and I'm looking at the email here. That the trial court shall hold a hearing and reduce its findings of fact and conclusions of law to writing and cause a supplemental clerk's record containing those findings to be filed with the clerk of the Court of Appeals, together with a reporter's record from the hearing, not later than 30 days from the date of the referral order. So that combines everything all in one.
Right. Richard.
Chip, I think that there's much to say for the simplicity of Chief Justice recommendation. However, my concern is the judges that are going to wait until the last day for the hearing, which is going to require the court reporters to apply for an extension. And so even though we may have an overall cap of 30 days, because we can't force the trial judges to do it sooner, it's possible they'll do it on the last day, and we're going to be looking at another 7-day deadline request to the Court of Appeals for the court reporter to transcribe it. And I think that there's some virtue in forcing the trial judges to get their job done 3 weeks into this, so the reporter can do their job in the next 7 days, and we'll end up with 28 days or 30 days. But if we leave it to the trial court, I'm afraid our 30 days is always going to be 37 days.
Judge Esteves, thank you, Richard.
I agree with Richard, and then I'd like to add some things to that. So I like both ideas. I would like a 30-day, everything has to be done, but the hearing has to be done in 21 days. And it's not because the trial judge, I'm going to defend all trial judges, but it's not because the trial judge doesn't want to do it within the 30 days. Sometimes there's the witnesses or the lawyers are busy and they don't want to change their schedules or whatever it may be, or it just sneaks up on them. And then all of a sudden it's day 28 and, we're in the middle of a jury trial and they're saying, we got to have this hearing. Well, whatever it may be, let's not just put fault on the lazy trial judge. Let's say that definite dates are always helpful. And the reality is that we have such a shortage of court reporters right now. We don't need to put the extra strain on them. So if we've had the hearing at day 21, they'll have 9 days to get that record. They'll probably still need an extension because they're going to be needed more to try to catch up in the backlog that we have from the COVID cases. So we're putting a lot of strain on those court reporters. And I guess I'm the advocate for my poor court reporter who is already overworked, and now we're going to give her more pressure. And if we will do it on day 22 or 25, I mean, that happens to us. And sometimes it's just because the lawyers can't get it done either.
All right, any other comments? It looks like Pam has got her hand up. Pam.
Well, maybe, after all of this, we do break it up into 2 piles. One would require the trial court to hold the hearing and make findings within 21 days, which is what we originally were looking at. And then to require the court reporter to prepare and file the record within 7 days of the conclusion of the hearing.
Okay. John Kim said we ought to recognize the reality of the court reporter's life. I think seconding what Judge Esteves was talking about. That's on a chat. All right. Anything else from anybody? Judge, did you still have your hand up, Judge Estevez?
No, this is a new one. I don't think the findings should be required until 30 days. I think if you have the hearing at 21 days, that'll give the parties a little time to get together what those, I mean, the reality is that usually when we do these hearings, we tell the lawyers at that point what our findings are going to be, and we make findings on the record, but then they fill in the gaps with whatever transcription, and they can ask for specific testimony. So I think it's helpful to have a 21-day hearing deadline and then a 30-day everything's due. Our findings are due, the transcriptions due, everything else is due.
Great, thank you, Judge. Richard.
Chip, I just want to make clear on the record that I have the greatest admiration for our trial judges, how dedicated they are, particularly the ones that are on this committee. And I didn't mean to insinuate that judges were lazy and went late to the last minute, but it's always a question of priorities on the district bench because our judges are overwhelmed. And so they have to go with the closest deadline. That's my point. And I didn't mean to disparage the judiciary at large, or particularly the members of this committee.
All right, you're covered up now. We got it on the record. You can point to that if anybody charges you with defaming our judges. All right, Bill, you want to frame I'm sorry, Judge Mendoza, do you want to respond to Orsinger there? I wouldn't blame you a bit.
Kind of. I want to say we're all defending the trial judges. No one's saying a bad thing. I think I'm a pretty good judge. I'm telling you, if you give me 30 days, sometimes it's going to get there. So I think all these suggestions are fair and we don't have to malign anyone, but it's tough. I will tell you, get those deadlines, and I don't think I'm a slacker. I'm just like Judge Estevez was telling you, things come up. It could be witness availability, or I could be in trial. There's a lot of reasons why we push it up until the very last moment. So I too would support the idea of a 21 deadline to 21 days for having the hearing, and then but wrapping it all up, every single piece, the reporter's record, the court's record, the supplemental record, I mean, within the 30 days, because I think that's long in these cases, but I think reasonable, and I don't take issue with the criticism.
I don't think he was criticizing you.
There was no criticism. There was no criticism.
All right, Bill, frame a vote for us. Those in favor of X.
All right, so so this is going to be a motion to approve what I understand to be the friendly amendment to the Judge Christopher proposal as follows. The motion would be that the rule will provide that the trial court will hold a hearing within 21 days of the date of the referral order, part one. Part two, then, is that the trial court shall reduce its findings of fact and conclusions of law to writing and cause a supplemental clerk's record containing those findings to be filed with the clerk of the Court of Appeals, together with a reporter's record from the hearing, not later than 30 days from the date of the referral order, period.
All right.
Can I wait to make one more friendly amendment? You want to say conclude the hearing by 21 days, not hold the hearing.
Yeah, that's a good point.
With that additional friendly amendment, I would move for the full committee to vote on that proposal.
Yeah, second, a lot of hands up, but do you all really want to? Oh, everybody's raising their hand because they're voting for it. Okay, good. Second, whoa, that. All right, keep them up for a minute. Okay, anybody opposed? Lower the hands for the ones that are in favor. Okay, Judge Wallace, your hand is up. Do you oppose, or is it an inadvertent hand?
No, it's a,
Okay, so we almost got unanimity, but not quite, because Judge Wallace voted against it. So we're 35-1, it passes. And we're going to take our lunch break right now, and we'll be back at 12:45. And when we come back, Bill, do we still have to talk about this tolling portion of the rule, or are we done?
That's the last piece of this, which would be, I think, an up or down vote on whether or not the committee as a whole wants to build in any kind of tolling into the 6-month limit under the rule of judicial administration.
Okay, well, think about that over lunch. We'll come back and have a discussion if we need one, but if we don't need one, then we'll just we'll vote on it and get on to the next agenda item. So we'll be in recess until 12:40.